Welcome back to LAWSTACHE channel. My name is Anton Vialtsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to discuss the Fourth Amendment and whether you should have a reasonable expectation of privacy in a hotel room. And then we're going to briefly discuss Jacobson case, which deals with a private search exception, which I of course discussed last week. So of course I ask you to revisit those videos last week to have a better understanding of this exception. And before we go on, I want to thank you for watching me on YouTube. And if you're listening to the audio recording in a podcast form on Audible or Spotify, please give my podcast a 5-star review rating. And during the month of December, if you go on my website at lawstache.com, you can purchase my t-shirts and other merchandise at 10% off if you put in a code THANKS2022. Let's go ahead and discuss this case.
Quick message from LawStache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vialtsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LawStache YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LawStache YouTube page. That's LAWSTACHE.
Today we're discussing a Ninth Circuit case, United States versus Michael Young. In 2007, a guest by the name of Johnson was staying at the Hilton Hotel. At some point, when Mr. Johnson returned to his room, he noticed that some items were missing. Somebody stole his computer, tablet, and some other personal items. Mr. Johnson went to the lobby of the hotel room and told the clerk about the theft. Now the clerk did a records check and noticed that the defendant in this case, Mr. Michael Young, was accidentally given the key that opened the door to Johnson's hotel room. Now, Mr. Young was also a hotel guest, but he was staying at a different room. So the clerk told the security officers, who went up to Mr. Young's hotel room. They knocked on the door. When nobody answered, they used a master key to enter the hotel room. And inside, they found the hotel room was mostly empty, and the only item that was there was a backpack which contained a firearm. Of course, they opened the backpack to notice the firearm. They never called the police. Instead, they waited until Mr. Young returned to the hotel room, which happened hours later. When Mr. Young returned to the hotel room, he tried entering, but he noticed that his key was no longer working. That is because the security locked him out of his own hotel room. At this point, only a master key would open that door. Mr. Young would go downstairs to talk to the clerk at the lobby, at which point the clerk called the police. One police officer arrived to the scene. He questioned Mr. Young without ever giving him Miranda rights, and eventually he would handcuff him to a bench. At that point, the police officer would call his sergeant and ask him whether he had permission to enter Mr. Young's hotel room to search for the items and other evidence of the crime. The sergeant told the police officer that he did not have permission to go in. That would be a violation of the Fourth Amendment. Instead, the sergeant told the police officer that security or other staff at the hotel could enter the room. So the police officer, together with a security officer working at the hotel, went up to the floor where Mr. Young was staying. They opened the door using a master key. A security guard alone entered the room while the police officer stood outside the door looking in. At that point, the security officer, opened the backpack and revealed a firearm, which was quote-unquote in plain sight to the police officer. And only then did the police officer would go into the room, retrieve the firearm, and search the room without a warrant. Quick interruption. Sorry, did you notice that none of the items belonging to Mr. Johnson were ever found in Mr. Young's hotel room? Think about that. Alright, let's go on. Now, Mr. Young was later charged with being a felon in possession of a firearm and other crimes, but he argued that the Fourth Amendment protected him against unreasonable search in violation of the Fourth Amendment because there was no warrant and no exceptions applied. Remember, the Fourth Amendment protects you against unreasonable searches and seizures. And Mr. Young said that he had a reasonable expectation of privacy, that nobody would enter his hotel room. The government argues the opposite. The government says that no, Mr. Young did not have a reasonable expectation of privacy in a hotel room because he was evicted. And alternatively, they argued that this was a private search under Jacobson's case. That is an exception where a private individual searches the hotel room or other items first. And as long as the police did not extend the scope of that search, they can do it without a warrant. The Ninth Circuit starts with the basics. The Fourth Amendment protects you against unreasonable searches and seizures, meaning that generally speaking, officers need to have a warrant before they search or seize you. And of course, part of what you purchase when you lease a hotel room is privacy in your own person and your own belongings that you leave in the hotel room. And just because you're arrested or detained outside of your hotel room, you do not lose your privacy rights in the items that you leave behind in your hotel room. Unless, of course, you are evicted from that hotel room and no longer being a guest there. Now, the Ninth Circuit says that Mr. Young did not lose his reasonable expectation of privacy for a number of reasons. And here they are. The hotel had not taken any affirmative act that was a clear and unambiguous sign of an eviction. Upon returning to his room and seeing that his key did not work, Young might have reasonably have believed his key to be defective or demagnetized, rather than suspecting that he had been evicted from the room. Numerous other facts militate against the factual finding that Young had been evicted from his room, including, number one, that Young was never told by any member of the Hilton security staff that he had been evicted. Number two, Young's belongings were never removed from his hotel room and placed into storage. Number three, there was no evidence that Young had been removed from the registered guest list at the hotel at any time of the search. Number four, Hilton search staff did not contact the police after first discovering the firearm, but instead chose to contact police only after Young returned to his hotel room and found that he had been temporarily locked out. And finally, at the time of the warrantless search and seizure, both Hilton security staff and the officer appeared to consider Young to still be in possession of the hotel room. The security staff repeatedly referred to room 13575 as Young's hotel room, and the officer told the agent that his supervisor said that he could not enter again Young's hotel room. And the government does not dispute that the staff working for the hotel were operating under the directions of the police officers, meaning that they were governmental agents for the purposes of the Fourth Amendment. Additionally, we can agree that most people who steal from hotels don't return to the same hotel rooms and the same hotels. And the fact that Mr. Young tried to return to his own hotel room and tried to gain entry there proves that he had reasonable expectation of privacy in that hotel room because he thought that it was still his room for the time being. And the fact that the government and the hotel staff never took affirmative actions to evict Mr. Young also shows that the government and the staff thought that the room still belonged to Mr. Young, again for the time being. And for those reasons, the Ninth Circuit concludes that Mr. Young did in fact have reasonable expectation of privacy, and this search was in violation of the Fourth Amendment. Now, moving on to the second argument, the government says that Jacobson private search exception should apply. Now, Jacobson was a Supreme Court case where FedEx mailman opens a package, sees drugs there, later calls the police, and the Supreme Court, held that police officers did not violate the Fourth Amendment even though they opened the package without a warrant and without any other exceptions to the warrant requirement. The fact that the private search occurred first and the government did not exceed the scope of their own search later on, meaning they did exactly the same actions that the private party did not, for that reason, it did not violate the Fourth Amendment. Now, in Jacobson's case, the only item that could have been inside the package were drugs. The Ninth Circuit in our case says that Jacobson exception does not apply because when you enter somebody's room, it is not necessary that only incriminating evidence would have been found inside. In fact, the first security officer who entered Mr. Young's hotel room and found a firearm did not know that there was anything illegal about the firearm. He had no way of knowing that this firearm was in possession of a felon. And there's nothing illegal about owning and possessing firearms, at least in the state where that case originated. Now, for that reason, the private search exception did not apply. And the evidence found, including the firearm and any other items in that room, should have been suppressed. And in fact, they were. So the Ninth Circuit says that Mr. Young was correct from the district court level, and now at the appellate court level, the Fourth Amendment protected him, even in his hotel room, against an illegal search by law enforcement. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. Thanks for watching.